Most homeowners over 60 assume their home is protected. They paid it off. They have a will somewhere. They have been responsible their entire lives. And they assume that means everything is in order. For most of them, it is not. Not because they did anything wrong, but because the documents that actually protect a home after 60 are specific, and most people are missing at least one of them. Some are missing all 5. This video is not legal advice. It is not meant to overwhelm. It is meant to answer one simple question: do you actually have what you need in place? Because after 60, the stakes around your home change, and the documents that protect it matter more than most people realize. For most people, the home is the largest asset they will ever own. It is not just where they live. It is decades of mortgage payments. It is the thing they plan to leave behind. It is the financial foundation everything else is built on. Before 60, most people think about protecting their home in terms of insurance and keeping up with payments. After 60, the risks change completely. Health becomes less predictable. The possibility of incapacity, even temporarily, becomes real. A spouse can pass away unexpectedly, and the question stops being, how do I keep this home? It becomes, what happens to this home if something happens to me? That question is answered entirely by 5 documents, and the gap between having them and not having them is not a small one. It is the difference between your family receiving what you intended and a court deciding for them. The first document is a will. Most people know they should have one. Far fewer have one that actually reflects their current life. A will tells the court who gets what when you die. Without one, the state decides. Not your family, not your wishes. The state follows a legal formula based on relationships, not intentions. A living trust bypasses the court entirely. When a home is held inside a living trust, it does not go through probate when the owner dies. It transfers directly to whoever was named as the beneficiary. No judge, no waiting period, no legal fees eating into what gets left behind. A living trust also protects the homeowner while they are still alive. If they become incapacitated, the person named as successor trustee steps in immediately to manage the property. No court proceeding required. No waiting for a judge to appoint someone. The transition happens according to the plan, not according to what the legal system defaults to. The most common mistake people make with a living trust is creating one and never actually using it. A trust is only useful if the home is titled in the name of the trust. If the document exists but the deed was never transferred, the home still goes through probate. The document alone is not enough. The home has to be inside it. The third document is a durable power of attorney. This is the one most people do not think about until it is too late to get it. A durable power of attorney gives someone the legal authority to manage financial affairs if the homeowner becomes unable to. Pay the mortgage, handle the bank accounts, make decisions about the property. The word durable matters here. A standard power of attorney becomes invalid the moment someone is incapacitated. A durable power of attorney stays valid precisely when it is needed most. Without one, if a stroke happens, if dementia sets in, if there is a serious medical event, no one has automatic legal authority to act. Not a spouse, not an adult child, not the closest family member in the world. They have to go to court and petition for guardianship or conservatorship. That process takes months. It costs money. And while it is happening, mortgage payments still come due. Bills still arrive. Decisions about the home still need to be made. And legally, no one can make them. Here is the part that matters most. A power of attorney cannot be signed after someone loses capacity. The document has to exist before it is needed. Once incapacity arrives, the window to create one has already closed. The fourth document is a medical directive, sometimes called an advance directive or a living will. This one does not protect the home directly, but it protects the person and the family around them at the moment when everything else stops mattering. A medical directive states a person's wishes for medical treatment if they cannot speak for themselves, what interventions they want, what they do not want, who has the authority to make those decisions on their behalf. Without one, doctors follow protocol, and family members are left making impossible decisions with no guidance. In the worst moments of their lives, families fracture over these decisions. Siblings stop speaking. Spouses are overruled by hospital procedures. Adult children are asked to make calls they were never prepared for. The medical directive removes that uncertainty. It gives the family permission to honor what their loved one actually wanted, without guilt and without conflict. And it removes the burden of impossible choices from the people who are already carrying enough. The fifth document is the one that gets overlooked most often because it does not feel like something that needs to be actively managed. It is the deed, specifically how the home is titled, who is named on it, and in what legal capacity. For married couples, how a home is titled determines exactly what happens to it when one spouse dies. Joint tenancy with right of survivorship means the property passes automatically to the surviving spouse. No probate required. Tenants in common means each owner holds a separate share, and when one dies, their share goes through their estate, not automatically to the survivor. Many couples do not know which one they have. And even with a will, a home does not automatically transfer to your heirs the moment you pass. It still goes through probate, the court-supervised process of validating the will and officially transferring ownership. In most states, probate takes between 6 months and 2 years. Legal fees typically run between 3 and 8% of the estate's value. On a home worth $300,000, that is up to $24,000 in fees before anyone inherits anything. The other issue is that most people have not looked at their will in years. The beneficiaries named in it may no longer reflect their actual wishes. A will written in 2005 does not know about the grandchildren born in 2015. It does not know about the divorce. It does not know about the family member who is no longer in the picture. A will is only as useful as its most recent version. The second document is a living trust. A will tells the court what you want. They signed documents at closing decades ago and never looked at the deed again. A deed titled incorrectly can undo everything else. A living trust that never had the deed transferred into it provides no protection. A will that contradicts how the deed is titled gets overruled by the deed. The deed is the foundational document. Everything else works around it. And for most homeowners over 60, the last time they saw it was the day they bought the house. Without these documents in place, the consequences are specific and they are real. A home without a trust goes through probate, months of court proceedings, thousands of dollars in legal fees, family members unable to access or sell the property until a judge permits it. A missing power of attorney means a court gets to decide who manages the home, not the homeowner. An outdated will means assets go to people who were named years ago, not the people who were intended. A missing medical directive means the family makes decisions under pressure with no guidance and often with conflict. A deed titled incorrectly means even the best estate plan cannot do what it was designed to do. None of these outcomes require a mistake. They just require not having the right documents in place. And most people over 60 are one unexpected event away from finding out which ones they are missing. This is not about expecting the worst. It is not about living in fear of what might happen. It is about making sure that everything built over a lifetime, the home, the equity, the plan, goes exactly where it was intended, without a court deciding, without a family conflict filling the gap, without a months-long legal process standing between a loss and a resolution. 5 documents. A will that reflects current life. A living trust with the home actually titled inside it. A durable power of attorney signed before it is ever needed. a medical directive that speaks clearly when words are no longer possible, and a deed that is titled the way it was actually intended. Most people over 60 have some of these. Very few have all 5, current, correct, and aligned with each other. That is worth knowing. If this video gave you something useful, subscribing means you will not miss what comes next.